All right, let's continue our discussion about the 911 calls that we just heard. News 13's Kelly Cook joining us outside the Seminole County Criminal Justice Center. And Kelly, we heard not one, not two, not three, four, but five different chunks of 911 calls that we had not heard until, well, now and more in detail. The common denominator, though, for those five calls is that George Zimmerman seemed pretty calm when making those phone calls.
Absolutely. It was very similar to the phone call that he made on February 26th of 2012, the night he shot and killed Trayvon Martin. And then one call that they just played for the judge was made just a couple of weeks before February 26th and that night where Trayvon Martin was shot. It was very similar that they were saying there that, you know, George Zimmerman always started the call saying there's been a number of break-ins in my neighborhood, always described the suspect as being a young African-American male who seemed to be suspicious in the neighborhood, going between the homes. So they're saying the state that is relevant. There's relevance there. They want to put that in. The defense, not so much. They're saying, what does that prove? He was doing what he was supposed to do as a neighborhood watch. Let's listen to the arguments.
Appellant's credibility was at the heart of this case, and it would have prevented the state from fairly and adequately making its case against appellant if the evidence was excluded. That is squarely the situation we have in this case. I would also point out that the defendant himself created these calls. He created these tapes. He created the situation. He's essentially responsible for everything that has been admitted so far. It's him that picks up the phone and makes these statements. So he shouldn't be allowed to complain about it.
In effect, what the state is going to show the jury, if you allow that evidence, is 4, 5, or 6 acts where my client has contacted the police to say, hey, come check it out. None of which is going to show ill will, hatred, spite, second degree. Then what they're going to do is say, aha, remember we told you about profiling? Well, now we want you to presume that when he acted reasonably those 5 or 6 times, he was seething under the surface.
All right, let's bring in News 13 legal analyst Mark NeJame, who is standing by. Mark, good morning.
Good morning.
Well, I tell you what, I do not think, I was telling everybody here that I could be a judge, because every time they make arguments, they make such good arguments, and I go, that's a good point. But that's a good point. So you are the professional, so you tell me, what do you think about the arguments and which way the judge might lean?
Well, I don't know about you being a judge, but you'd make a heck of an attorney. You're spot on all the time with your analysis. I've been beyond impressed, Kelly. The issues here are really both of them taking a portion of the evidence code and using it to their advantage. You heard references like to 401. Well, 401 is basically relevant evidence, and the state is claiming that they should be entitled to get these 911 tapes in simply because it's relevant. It shows the state of mind of the defendant, that they use the word seething, and that's appropriate, that basically that he was a pressure cooker building over time, and at some point, particularly as it came to the nexus with Trayvon Martin, that he blew. And that they want to bring all this in because they claim that the state of mind is relevant to second-degree murder. And in fact, they want to be able to show all these calls were a build-up, build-up, build-up to finally the fatal night when, in fact, Trayvon Martin was killed. The defense, on the other hand, you hear about Williams' rule in 404. Well, what they're trying to claim is that, no, this is similar fact evidence, and under the rules of evidence, you have to give at least 10 days' notice to the other side if you're going to use similar fact evidence, and they're claiming it's not similar fact evidence, that these were otherwise good acts. This was a good Samaritan calling in his position as a neighborhood watch captain, and that by him going ahead and calling in, they're trying to take a good act and use it against him concerning this fatal night, and that they didn't provide the requisite 10-day notice. So you see this competition, this tension between these two issues. And the judge fully, once again, understands all the legal issues. They've given her a packet of about 20 cases, and she's going through them and going to figure out is the 401, 402 application applicable, or is the 404B, the Williams rule application applicable. And I think what the defense is arguing is, this is just a ruse. Once again, you never heard the state talk about racial, but the 5 calls that they pulled were specifically dealing with Zimmerman's call-in on African-American males. So, once again, the state never needs to say one word about the fact that this was racially motivated, but they continue to build this specter and to build this case where it's showing, where they're attempting to show that the profiling is the equivalent of racial profiling. So the defense and the state and the judge are all well aware of what's really going on, and the state is trying to get it in through claiming that it's relevant to build their case for second-degree murder, and the defense is saying, no, this is similar fact evidence, you didn't give the requisite notice, and it's not even applicable under the rules anyway. So therein lies your challenge back and forth, and the judge is going to go study this and land on an opinion. Let me tell you why it's so important. One, for fairness for a trial for both sides, but also remember that if the defense loses, they have a right to appeal. The state has no right to appeal in the event of an acquittal. So the judge wants to make sure that our rulings are legally sound. I've been beyond impressed. As each day passes, I become more and more impressed with the way Judge Nelson is handling this. It's interesting. I read Facebook, I read my Twitter, and people think that she's one way or the other, and which is often the sign of a good judge, that one day she might be pro-prosecution, another day they think she's pro-defense. She's really trying to follow the law and seems to be following the law the best way she can interpret it. And so far, I think she's been landing just about right every time.
Absolutely. Cannot be easy, Mark, when you're talking about a case that is garnering such national and international attention. At one point, I don't know if you remember back in the hearing, she's very much aware that she's got all eyes on her when she made the joke about the fax machine. I'm not quite sure if you remember that, but she was saying, oh, great, now the whole world knows I don't have a fax machine. Thank you, everyone. So she knows the magnitude of this case, but also that she can handle it. And so we're going to be waiting on that ruling to come down any moment, sometime either today, maybe tomorrow. But they're going to continue on with testimony right now. So, Mark, please stand by. We'll come back to you in just a bit. Let's go back to our gavel-to-gavel coverage.